Good morning, sir. Good morning, sir. Please unmute your mic, sir. Jan Kumar, sir. Please unmute your mic, sir.
Yes.
Good morning, sir.
Yeah. Good morning.
Good morning, sir.
Can you see me?
Yes, sir.
Yes. Okay. That's good.
Shall we begin, sir?
Yeah, no problem.
Okay, sir.
Good morning, everyone. I welcome the resource person, dignitaries, and all the participants to the second technical session. It's my privilege to welcome and introduce Professor Jan Kumar Saha. He has served in the capacity of principal and reader of Bengal Law College, Shantiniketan, West Bengal. Later in 2007, he was appointed as assistant professor in Department of Law, University of Burdwan, West Bengal. Professor Saha has been awarded with Australia India Council Senior Fellowship in 2011. He was also an associate investigator of UGC, UK India Education and Research Initiative Thematic Partnership Project 2013 and visiting research fellow, University of New South Wales, Sydney, Australia. He has also worked on many research projects and published research articles in national and international journals. He has presented research papers in various national and international conferences. Presently, he is working as professor and HOD of law, Bangalore University, West Bengal. I welcome you, sir. Welcome, Honorable Vice Chancellor of Karnataka State Law University, Registrar, Dean Faculty of Law, Registrar Evaluation, Director of Faculty Development Program, and all the participants present here. I request Professor Jan Kumar Saha to deliver a lecture on law and aged persons. So please.
Just a minute. VC sir is online.
Yes.
Professor Jan Shah.
Yes, sir. Good morning.
Good
morning, sir. Morning, sir.
Welcome. Thank you very much for agreeing to deliver a lecture on this.
Thank you, sir. It's my honor, sir.
You are expert in this area.
Right, sir.
Yes, that will be helping our faculty development participants.
Right, sir. Right.
Thank you very much. On behalf of university, I'm expressing my gratitude.
Thank you, sir. Thank you.
Yes,
Can I start?
I'll be participating. Of course, I will be listening to your lecture. Thank you.
Okay. Can I start now?
Yes, sir.
Okay. Good morning, everyone. First, I wish to have the privilege to welcome all my colleagues, the faculty members of different colleges and universities across India in this faculty development program in law and the vulnerable, organized by the Karnataka State Law University, which is a very significant initiative, especially in this very challenging time when we are separated from each other. First, I would like to convey my sincere thanks and gratitude to the Honorable Vice Chancellor, Professor Ishar Bhatt, for giving me an opportunity to share my views with you on the given topic, law and aged persons. I would also convey my thanks to Professor Ratna R. Varamgaudar, director of this program, who contacted with me on behalf of the university. I firmly believe huge advancement of students, teachers, and scholars in terms of application of technical knowledge and upbringing of the science. This type of program is a major milestone. You know, now the country is going through the unprecedented time of pandemic situation. And due to the grace of technology, we all connect with each other. And we are taking advantage of that in this faculty program as well. Sir, and the moderator who have introduced me already said that I have acquired some experience as an academic research fellow in our country and abroad in this particular subject about which I am going to share my views with you. I have some work experience in gerontology as a research associate with UGC UKD thematic partnership project with Swansea University in United Kingdom. But one thing, it's not possible for me to share the screen due to some technical fault of my laptop. Instead of that, I am using my smartphone. So please excuse for that. So today, our topic is law and aged persons. So why it is so important to promote the rights of aged persons? You appreciate that aged persons, it means senior citizens, are the treasure of our society. They link with past, present, and future. They can pass family values to the upcoming generation. If you tender your respect to older people's rights, society will get benefits as a whole. Because older people make key contributions to any society through their experience and wisdom. Better protection of older people's rights will allow societies to better capitalize on the potential older people. Definitely, aged peoples are enormous contributions to our next generation, including the whole society. Elderly peoples carries immense experience of their personal and professional life. And they can provide a vital generational link for upcoming generations. It provides support and stability to families and society at large. Grandparents in joint families provide a crucial link for transferring values and morals to the younger generation in their initial years, and thereby contributing towards upbringing of better human beings and responsible citizens. Their deep cultural impressions and social experiences provide the necessary buffet against intolerance, violence, and hate crimes, which provide stability in society, especially in the era of hate and crime. Elders also desire a life with good health, dignity, economic independence, and finally, a peaceful death. They long for care, love, and affection. If you understand their needs and concerns, it will ensure their good health. So if we want to give some honor to our elders, then we should spend time with them and listen intently, be polite, sometimes ask for advice, eat together, discuss family heritage, history, and traditions. Sometimes call them, tell them how much you appreciate and respect them, and sometimes visit some senior living communities. So in this way, we can show our respect to our senior citizens. But what is the general scenario? General scenario has completely different. From my research study in my own country and also United Kingdom, we have identified some of the common problems of the older people. And according to the National Council on Aging, about 92% of seniors have at least one chronic disease, and 77% have had at least two chronic diseases like cognitive health, mental health, physical injury, malnutrition, and oral health and substance abuse. If in a society where there are poor facilities for sanitation, infrastructure, and healthcare, it is the elderly people who suffer the most. In the Age Well Foundation survey in 2015, it was found that the elderly in India suffers some major problems like lack of gainful engagement opportunities, declining health status, lack of respect in family and society. And the most important problem is loneliness and isolation. There are also some psychological issues, financial problems, legal issues, and of course, interpersonal problems. So some elderly has no institutional care or medical system around them, and they have to depend on community care or family care to support them, especially in India. Generally, elderly women are seen to have no time for leisure or recreation and have lesser possibilities than men to lead retired life. You know, the elderly suffer lack of emotional care, support, and elder abuse more in urban areas than rural areas. They also face physical and psychological problems, include health and medical problems, nutritional deficiency, and the problem of adequate housing. They also face psychosocial problem, which covers problems related with their psychological and social maladjustment, as well as the problem of elder abuse. So along with these social, medical, and psychological issues, there exist many economic issues. And this economic dependency high among females. In case of disadvantaged section, the dependency level is even higher. Economic necessity forces the elderly people to work and earn the money. But why the economic problems are there? It's nothing but to loss of employment, income deficiency, and economic insecurity. So this shows the lack of social security to support the old-aged people. Even the government policies and norms are not efficient enough to assure the security. Our study also identified the incidence of loan taken to meet the medical expenditure of the elderly. So now I like to discuss about some common problems which faced by the elderly in the United Kingdom. Many people look forward to retirement, viewing it as a time to finally relax, slow down, and peacefully enjoy life. While it's true that the golden years can be some of the best years of life, there are still some significant challenges. But older adults face particular problems due to their age and the life circumstances. At the time of our research study, we identified some type of physical and mental health problem of the senior citizens in the United Kingdom. Many older adults maintain good health and are fully able to function both physically and mentally into their latter years. But however, the biological effects of aging lead to more physical and mental health problems among the senior population than in younger age groups. As age, muscles and bones begin to weaken. People lose eyesight, hearing, losses hearing, and mobility often becomes limited. Seniors also suffer from dementia, including Alzheimer's disease, which affects about 10% of people over age 65, increasing to 30% of people 85 and older. So due to physical or mental health conditions, about 2/3 of all older people need assistance with at least one daily living activity, such as bathing or preparing a meal. Older adults visit the doctor and stay in the hospital more often than other age groups. So Medicare covers some healthcare costs for seniors. However, most are left to pay for about half of their medical bills on their own, which can cost thousands of dollars each year. And some residential nursing homes are there, and they are still a primary option for seniors who need around-the-clock care. And upon retirement, most seniors lived on a fixed income, which along with the constantly increasing cost of living, which can pose many financial restrictions. They may no longer be able to afford the same lifestyle they had been accustomed to. So sometimes many older adults receive social security benefits. The UK government provide that help to supplement their income. However, 2/3 of those survive solely on social security payments who live below the official poverty level. And they also have some social isolation and loneliness problem, what I have already said. Seniors tend to have fewer opportunities for social engagement than younger age groups. They retire from jobs, children move away, friends and spouses pass away, and eventually they may become housebound if they lost the ability to drive or become ill. And mourning is always a difficult experience because so many seniors lost a spouse. It is a particular problem in their lives. The grief that follows the loss of a spouse can last many years and can involve anxiety, depression, loneliness, and some other issues. Of all these problems, loneliness is perhaps the most common and most difficult to overcome. So according to the most recent UK census, 28% of people aged more than 65 lived alone, with numbers estimated to be much higher now. Research studies also shows seniors who live alone often experience social isolation and chronic feelings of loneliness, which cause depression, illness, and even death. So it's hard to tell exactly how many seniors are affected by elder abuse due to the fact that few report it. Actually, nobody report it. It is estimated that at least 10% of older Englishmen have suffered from at least one form of abuse, which amounts to hundreds of thousands of cases per year. And sadly, some seniors are victims of abuse committed by their own relatives. And such abuse involves physical or sexual violence, psychological or emotional abuse, neglect, and also financial exploitation. So elder abuse poses a serious health problem for those affected, and it may even increase their chances of dying. So now we'll discuss about the international efforts in this regard. The question of aging was first debated at the United Nations in 1948 at the initiative of Argentina. The issue was again raised by Malta in 1969. And in 1971, the General Assembly asked the Secretary General to prepare a comprehensive report on the elderly and to suggest guidelines for the national and international action. In 1978, Assembly decided to hold a world conference on aging. And according to that particular World Assembly on Aging, it was held in Vienna from July 26 to August 6, 1982, wherein an international plan of action on aging was adopted. The plan attempted to promote understanding of the social, economic, and cultural implications of aging and of related humanitarian and development issues. The International Plan of Action on Aging was adopted by the General Assembly in 1982, and the Assembly in subsequent years called governments to continue to implement its principles and recommendations. The United Nations General Assembly on December 16, 1991 adopted 18 principles and the United Nations General Assembly, they actually adopted 18 principles, namely independence, participation, care, self-fulfillment, and dignity of the older persons. So we have already discussed about the problems faced by the senior citizens, not only in India and also in UK, and the international organizations' principles, which provide a broad framework for action on aging. So the aged people are very much needed some protective measures from the domestic legislations. And the issue of the protection of elderly persons' rights becomes very sensitive. Although in our present days, there is a random upliftment of our lives towards a modern and globalized society, the traditional norms and status randomly degraded. They lack physical, financial, and emotional support. They are totally exposed to such a vulnerable situation where there is no one to act as a balm to their wounded souls, not even their own children. So to eradicate this agony, some legislative measures are taken into force. But to some extent, these particular legislations are inadequate to cope all the complicated and problematic situations. So Article 21 of the Indian Constitution protects life and personal liberty of an individual. But the judicial intervention expands the scope of Article 21, by which include the various types of rights, including rights to enjoyment of pollution-free and healthy environment, the right to health and medical care, emergency aid to medical facilities, right to livelihood, right to live a dignified life, right to social security, and rights to live with proper or just reputation of a person. So provisions have been made in the Constitution of India to preserve the rights of those aged above 60. Since Chapter 4 of the Constitution, which corresponds to actually directive principles, they cannot be enforced by a court of law as stated in Article 37. However, they are the basis upon which any legislation is drafted. So Article 41 of the Constitution secures the right of senior citizens to employment, education, and public assistance. It also ensures that the state must uphold these rights in cases of disability, old age, or sickness. And meanwhile, Article 46 asserts that the educational and economic rights of the elderly must be protected by the state. So as per rights guaranteed under the central government already introduced the national policy for older persons in 1999. It says that all Indian citizens aged above 60 are entitled to a 30% concession in ticket prices while traveling with the Indian Railways. The concession is 50% for women aged above 60, along with the provision for separate counters and other services, including birth request. Air India is also bound to provide a concession of 40% to senior citizens at the time of taking a booking for economy class. And these are all under the National Policy for Older Persons in 1999. And apart from it, different religions have varying laws to protect the interest of senior citizens. And some are very particular, such as the statutory provision for maintenance of parents under Hindu personal law contained in Section 20 of the Hindu Adoption and Maintenance Act 1956. This particular act is the first personal law statute in India which imposes an obligation on the children to maintain their parents. The obligation to maintain parents is not confined to sons only, and daughters who also have an equal duty towards their parents. And it is important to note that only those parents who are financially unable to maintain themselves from any source, they are also entitled to seek maintenance under this act. And Section 20 of the Adoption and Maintenance Act 1956 makes it obligatory provisions to maintain aged parents. Similar laws are also found in Muslim laws, Christian laws, and even Parsi laws. If we go through the Muslim law, we see children have a duty to maintain their aged parents even under the Muslim law, and according to Mullah, children are bound to maintain their poor parents, although the latter may be able to earn something for themselves. They may be earned, but the children are bound to maintain their parents. A son who, though poor, is earning something is bound to support his father who earns nothing. But Christians and Parsis law have no personal laws providing for maintenance for the parents. Parents who wish to seek maintenance have to apply under provisions of the Criminal Procedure Code. So, Christians and Parsis laws have no such type of provision for maintenance. Want to get some maintenance from their, they have to apply under Section 125 of CRPC. Provision for maintenance of parents under this code. The law there will be considerably difficult in the amount of maintenance awarded to parents. And it is desirable to leave the matter for adjudication by civil courts. But the provision, however, was introduced for the first time in Section 125 of the Code of Criminal Procedure in 1973. And it is also essential that the parent establishes that the other party has sufficient means and has neglected or refused to maintain his, that is the parents, who is unable to maintain himself. And it is important to note that CRPC 1973 is a secular law and governs persons belonging to all religions and all communities. Daughters, including married daughters, also have a duty to maintain their parents. So these are all about our Indian legislations. And apart from it, if I go through the income tax is concerned, then section 88B, 88D, and 88DDB of the income tax of India allows senior citizens to claim a discount in tax. The elderly are also entitled to get higher interest on tax, and they have some savings plans apart from having a wide variety of LIC policies and post office savings schemes to choose from these policies. And when we are discussing about the Maintenance and Welfare of Parents and Senior Citizens Act 2017, it makes a legal obligation for an heir to provide a monthly allowance to his or her parents who are senior citizens as maintenance. The act has been widely criticized by policymakers for its vague provisions, and many experts have stressed the importance of clearer legislation to safeguard the rights and interests of senior citizens in India. So we have to discuss about the salient features of this Senior Citizens Act, because this is the most important act in India. No doubt, this is an unique act dealing with the issue of senior citizens. The legislation provides for the maintenance of parents and senior citizens. The definition of maintenance covers all necessities and requirements of life. It also includes childless senior citizen. He can claim maintenance from other relative who is a legal heir of that senior citizen, or who is in possession of or would inherit his property after his death. The state government has to constitute the tribunal. The tribunal can take cognizance suo motu as well as upon receipt of application by the senior citizen. So its jurisdiction is very wide. And the maximum maintenance allowance may be prescribed by the state government, which shall not exceed rupees 10,000 per month. The person against whom an order is passed has to comply with the order within 1 month. In holding inquiry, the tribunal may follow summary procedure, and it has all the powers of the civil court. And copy of the order should be provided to the parents or senior citizens at free of cost. Appeals also are required to be filed within 60 days. But appeal can be entertained by the appellate tribunal beyond this period with sufficient explanation. The party cannot be represented by legal practitioner. State government has to establish and maintain old age homes, at least in each district, which shall have minimum 150 senior citizens who are indigent. So this act is having provisions for medical care for senior citizens. A senior citizen who has transferred his property either to his children or any near relative by virtue of a will or gift, he can cancel the same by applying to the tribunal if he or she is neglected or refused to provide basic amenities. So if they are abandoned with an intention by a person to take care and protection, then he is liable to punishment. So this act bars the jurisdiction of a civil court and further provides that no injunction shall be granted by any civil court in respect of anything done or intended to be done by or under this act. So from it appears that senior citizen is now protected from all sides. After the passing of this enactment, various bills came into force to rectify or improve the existing legislation. But in this act also, there are many gray areas. There are many lacunas for which the proper and effective implementation cannot be made possible. So we have to discuss these gray areas or lacunas. First of all, maximum monetary relief of rupees 10,000 is provided under this act, which is not adequate to the person who is residing in a city or who is suffering from any illness where medical expenses is huge. Not only that, sometimes it appears that against whom the order is made, the person concerned is rich enough to bear more burden. So this is a great loophole of this act. It must be amended. Secondly, total exclusion of legal professionals and total exclusion of the jurisdiction of civil court is not at all beneficiary. The participation of legal professionals must be optional. The old persons who are indigent can avail the benefits of legal aid. The Act mentions that subdivisional officer is to be presided as the officer of tribunal. He is already overburdened by his administrative works. Some legal technicalities may arise, or some situation may also arise where the presiding officer has to declare any right, title, or interest in favor of the aggrieved party, which is beyond the power of an administrative officer. So in these situations, the court can handle it more maturity and excellencies. Therefore, total exclusion of court's jurisdiction is not justified. The Act follows the state government to establish old age homes, but it does not make it mandatory. The Act does not clear the view regarding the taking of responsibility of senior citizens who do not have children or who do not have any relative. In that situation, whether state will take the burden or not, and what will be the extent. If the son is indigent, how can he maintain his parents or grandparents? How would the tribunal adjudicate such disputes? So all those provisions should be inserted by new amendments. And a situation may arise where parents who have no son but only daughters, and they reside with their daughter and son-in-law, then can son-in-law be included in the definition of children under section 2A when the daughter is non-earning? So the purview of the definition should be wider. Another point is worthy to mention here, that when the son is rich, NRI, and his parents are living in India, what would be international as well as municipal law by which the rich NRI would have no other option to maintain his parents properly? Therefore, these gray areas should be clarified by effective and proper implementations. And according to the provisions of this Act, liability can be imposed on a person who happens to be a relative of that senior citizen on the stipulation that in near future, that person will inherit the property of that senior citizen. So it is totally unreasonable because there is no guarantee that the said relative will get the property. The senior citizen can sell the property to any other person, or he can make any will in favor of any other person before his death. Therefore, change must be there regarding this point. Another point, state government should make provisions for setting up the counseling centers, helplines, and organize seminars, programs to increase confidence among the old persons and to make them aware regarding their rights and the protection available in the statutory provision. So the legislations which are beneficiary to the rights of senior citizen and old parents need more publicity. NGOs, various organizations, and corporate sectors, through their CSR, it means corporate social responsibility program, should play active role to encourage the public participation in this regard. The Senior Citizen Act is passed by the central government, but still it has not been implemented by many states, and the states which implement this enactment, they do not pay any heed to redress the present problem with serious efforts. And whatever may be the laws, without effective implementing machinery, the very object cannot be achieved. Senior citizen, the senior citizen cell should be established by the state government, and police patrolling should be intensified in areas to decrease the crimes against elderly persons. So now the question comes, what is the role of judiciary towards senior citizens? You know, the judiciary plays a very important role as the protector of the Constitution and the basic guarantees given to citizens of the country. The rule of law is the backbone of our democracy, and the primary responsibility for implementation of the rule of law lies with the judiciary. The scope of writ jurisdiction has also been expanded to uphold the human dignity and the other fundamental human rights. An important case in Jogesh Sadhwani versus Commissioner of Police in 2015, a public interest litigation case was filed on behalf of Mrs. Jayashree Golkar. This case brought forth a complete failure of the execution of the Maintenance and Welfare of Parents and Senior Citizens Act 2007. The court directed the state government to file affidavit mentioning therein the steps taken to establish tribunal under Section 7, designate a maintenance officer under Section 18, for establishment of old age homes under Section 19, to give medical support to the senior citizen as under Section 20, for publicity, awareness, or any other manner for welfare of citizens under Section 21. So this case, therefore, is an example of judicial intervention to question the efficacy of the executive. Another important case in S.P. Gupta versus Union of India, AIN 1982, and a recent case, Shanto Surendra Patil versus Surendra Naksponda Patil, 2017. The litigation parties in the case were parents and their sons. The respondent was the son of the petitioners and was appealing against an order of vacation of the residential premises owned and constructed by the petitioners. The court went to discuss the need for the enactment of Maintenance and Welfare of Parents and Senior Citizens Act 2017. The moral duty to take care of one's parents was crystallized as a legal responsibility under this act. The state also takes itself the guardianship of senior citizens and old infirm parents. The eviction order was upheld by the court. As such, an order is permissible under Section 23 of the Act of 2007. Another case, People's Union versus Civil Liberties. The case is People's Union of Civil Liberties versus Union of India in 2007. As part of interim measures, several directions were given by the court regarding several schemes. Specifically, in regard to older persons, the states were directed to identify the beneficiaries and state payments under the National Old Age Pension Scheme. Such payments were to be made promptly by the 7th of each month. And there are so many other landmark judgments which directly help to uplift the vulnerable position of the deprived senior citizen. Right to have shelter, right to free legal aid, right to speedy trial, right against inhuman treatment. These are some of those particular rights. The Apex Court in one case held that the state is bound to protect the life and liberty of every human being, where he is a citizen or a non-citizen. And Apex Court also held that the people who are starving because of their inability to purchase food grains have right to get food under Article 21. And therefore, they ought to be provided the same free of cost by the states out of surplus stock lying with the states, particularly when it is unused and rotting. The court held that under such a situation, food grains be provided to all those who are aged, infirm, disabled, destitute women, destitute men, etc. So these are the role played by the Indian judiciary towards the rights of the older people. And the governments also take some initiatives, some welfare programs, which are government-funded schemes to provide financial aid and other such facilities to disadvantaged groups in the community. A separate department of senior citizens under the aegis of the Ministry of Social Justice was formed and appointed as the nodal agency for all matter relating to the implementation of the governmental policies and the national policy of senior citizens in 2011. Directorates of senior citizens in state and union territories and National Council for Senior Citizens would be established. And you know, Ministry of Social Justice and Empowerment is a nodal agency for the welfare of the elderly people. And the main objective of the different scheme is to improve the quality of life of older persons by providing basic amenities like shelter, food, medical care, and entertainment opportunities. And it's not possible for me to discuss in detail in a short time about the different welfare schemes initiated by the government, but I'd like to mention some of the important schemes before you. One is Rashtriya Bhayasri Yojana. Here, all unclaimed amounts from small savings accounts, PPF and EPF, are to be transferred to this fund. One is Indira Gandhi National Old Age Pension Scheme. In this scheme, the Ministry of Rural Development runs the National Social Assistance Program that extends social assistance for poor households, for the aged, widows, and disabled. Another scheme is Barishto Pension Bima Yojana. This scheme is run by the Ministry of Finance. These social security schemes for senior citizens intended to give an assured minimum pension on a guaranteed minimum return on the subscription amount. And in 2017, another scheme was launched, the Pradhan Mantri Vayo Bandhana Yojana, which provides social security during old age. And this will be implemented by the Life Insurance Corporation of India. So at the end, I must say that though there are several numbers of laws and government policies made for the protection of rights of senior citizens and old parents, but nothing much have been achieved so far. As we all know that our Indian society is blended with culture and emotion, it is really very difficult for parents to drag their children to the doors of the court or tribunal. And in most of cases, they start forgiving as well as sacrificing their rights. Because of these, the next generation does not have to face the proper lesson. The other side of the story is that when the technicalities of legal procedure enter into a house, love, affection, or bonding between the two generations faded away. Until the total mindset of our society is changed, unless they do believe in the notion that they are complementary and supplementary to each other, no law can change the scenario. It is noteworthy to conclude this lecture with the words of S.S. Hooper. I slept and dreamed that life was beauty. I woke and found that life was duty. So without performing the sacred duty, one cannot see the real beautiful life. Like a cheerless performance, but somehow in the end, it will give a lot of satisfaction. So thank you. Again, I convey my heartful thanks to the participants for patience hearing. Thank you.
Thank you for sharing your knowledgeable address, sir. I now request Mr. Girish Casey, Assistant Professor of Karnataka State Law University, to ask questions to resource person on behalf of the participants.
So thank you very much. Your lecture was very informative and you have sensitized all of us through your presentation. You have explained in a lucid manner the physical, psychological, psychosocial, medico-economic problem faced by aged persons. So most of the questions which are raised by the participants is already answered through your presentations. The questions were relating to barring legal practitioner and the jurisdiction of civil court. All these questions were answered during your presentation itself. And there are few questions which are raised by participants. And one question is like this. So what is your opinion on the decision of the government to decrease the rate of interest for senior citizen saving schemes when senior citizens are facing economic problems? What is your view on the decision of the government to reduce the rate of interest of senior citizen savings schemes?
Right. See, this is a very relevant question, not only raised by the participant, but also we all, the people, always think about it, that why the government regularly decrease the interest rate of the senior citizens investment. Because in our society, we know that the senior citizens at the time of his retirement, they earn something for his own life, and definitely they actually invest this amount of money to the bank for some interest, and which actually gives the senior citizens the rest of the life to run smoothly. But this is the decision of the government, decision of their economic policy. I don't know that why the government is not taking any other type of policies where the senior citizens benefits or the protections must be assured. So this is also a relevant question for me also.
Sir, one more question. What is the punishment for violation of provisions of Hindu Adoption and Maintenance Act and Senior Citizens Act?
What are the?
What is the punishment for violation of
Okay.
Senior Citizens Act?
No, actually, I have already said that this act actually provides a particular provision that the children, they have to give some maintenance to their parents, and if sometimes there are some laws that if the parents has not at all earned anything, and also if the parents earn something, then also the children have to maintain their parents. And if they do not do this, then there are some provisions of the penalty provisions are there, maybe a huge rate of fine. And I right now I am not recall exactly the penal provisions of that particular provision, but still there are some penal provisions are there.
Yes, sir. Sir, one last question. The question is too general in nature, but the participant has asked your views on this. Parents who made their will in advance suffer ill treatment by children. So the
Right.
parents who have made their will in advance, those are the persons who are suffering ill treatment by their children. What is your view on this?
The parents have every right to change their wills subsequently. But most of the cases we feel that the parents by affection or love, they actually very much habituated to accept this type of abuse, this type of non-maintenance of the by their children's, but still parents have a right to change their wills subsequently if the children do not maintain the proper treatment to the elders.
One last question, sir. Whether adoption
Yes.
of proposed UN Convention on Rights of Older Persons would help in realization of rights of this vulnerable group?
Please repeat.
Whether adoption
repeat
of
the question.
proposed UN Convention on the rights of older persons would help in realization of rights of this vulnerable group?
Definitely. Actually, the domestic legislations always insert some provisions and apply the resolutions of the international organizations. So the international organizations, the United Nations, when they actually resolve something, the state legislations, they also insert that type of provision in their own acts. So this will help for the protection and rights of the senior citizens.
Thank you. Thank you very much for answering the questions.
Thank you, sir.
Thank you.
I request Dr. Rangaswamy, Assistant Professor of Karnataka State Law University, to speak a few words. So please unmute.
Sir, thank you, sir. Thank you very much for an amazing and incredible speech on the topic. You have extensively covered almost all the material and collateral issues relating to topic that is senior citizens. As you put across, last few decades have accelerated deep social order so far as marginalized sections of the society is concerned. Sir, as you rightly pointed out, a light failure of the system in understanding and addressing the core issues of senior citizens is a powerful and least understood aspect responsible for such kind of crisis of senior citizens. As unfolded by you, sir, this failed system, structures and constraints, the very process of realization of the noble objectives of law. In this context, there is a striking need of reconstructing and renovating existing social order in the background of these crises. So our program is one such effort undertaken by Karnataka State Law University. Sir, your lecture could create a kind of responsibility for our participants, and it could create a kind of inclination for our teachers to look at changes required for their classroom approach while dealing with that topic, that is senior citizens. Your lecture has carefully located and meaningfully analyzed various core challenges associated with the existing legal system. I am of the sincere opinion that, sir, your critical scholarship would be deepening width and breadth of the perceptions of the participants at greater length. Again, on behalf of the Karnataka State Law University and organizing committee of this faculty development program, I extend sincere thanks to you, sir, for accepting our invitation and delivering such a vibrant lecture on the topic. Thank you, sir.
Thank you. Thank you.
Thank you. I deem it a great honor and privilege to propose vote of thanks on behalf of Karnataka State Law University. I would take this opportunity to thank Professor Jan Kumar Saha, Head Department of Law, Bankura University, West Bengal, for his thought-provoking lecture. Thank you, sir. I would like to acknowledge my gratitude to Professor P. Ishwar Bhatt, Honorable Vice Chancellor of Karnataka State Law University, Major Siddhalingaya Hiremat, KS, Registrar, Karnataka State Law University, Professor C.S. Patil, Dean, Faculty of Law, Karnataka State Law University, Dr. G.B. Patil, Registrar Evaluation of Karnataka State Law University, and Director of Faculty Development Program, and all the participants for their active participation. Thank you, one and all. We will reassemble for the next technical session.
VC sir is online.
Yes, sir.
Professor Jan Kumar Shah, thank you very much on behalf of the university.
Yes,
Your
sir.
excellent
Yes.
lecture and faculty development program has become quite effective because of participation by scholars like you. Thank you very much.
Thank you, sir. Thank you.
Thank you, sir. Thank you so much.
Okay. Okay. Thank you.
We will reassemble for the next technical session in another few minutes.
Yeah. Good afternoon, madam. Good afternoon, madam. Madam, please unmute your mic. Yeah, ma'am. You're audible. You are visible.
Yeah, good afternoon. Good afternoon, sir.
Good afternoon, madam.
Hello, ma'am. Welcome.
Good afternoon, ma'am. How are you?
Fine, thank you. Welcome to the session.
I heard that, it's a very good FTP program with a large number of teachers. More than 400 or 500 of teachers are joined there. It's an excellent FTP going on.
BC sir is online, madam.
Okay.
Gopalakrishnan, thank you for accepting our invitation and joining.
Thank you, sir. Thank you. Thank you very much, sir.
Thank you.
Anushree, you can start.
Yes, yes, ma'am. Good afternoon, everyone. I welcome the resource person, dignitaries, and all the participants to the third technical session. It gives me a great pleasure to welcome and introduce Professor Bismi Gopalakrishnan. Professor Bismi has done her BA LLB from Government Law College, Thiruvananthapuram, and secured highest marks with merit scholarship and LLM from University of Kerala in Constitution and Administrative Law with first rank. She has completed a PhD from University of Kerala in 2002. She joined as visiting faculty to the Department of Law, University of Kerala in 2002. In 2004, she was appointed as Assistant Professor of Law in School of Legal Studies, Kannur University. Again in 2005, she joined PG Department of Law, University of Kerala. She has more than 20 years of PG teaching experience and also successfully guided many PhD scholars. She has organized several national and international seminars and also published research articles in reputed journals. She was selected to take part in United States Department of State Bureau of Educational and Cultural Affairs Professional Exchange Program in 2011. She has worked in different capacities, to name a few: member of Research Ethics Committee, Health Action for People 2013, member of Advisory Committee for Science Research and Inventions in Schools for Technological Innovations, member PG Board of Studies, University of Kerala, and associate editor, Kerala University Journal of Legal Studies. She is also well versed in many foreign languages like French, German, and Russian. Presently, she is professor and HOD of School of Indian Legal Thought, MG University, Kottayam, Kerala. I welcome you, ma'am.
Thank you.
I welcome Honorable Vice Chancellor of Karnataka State Law University, Registrar, Dean, Faculty of Law, Registrar Evaluation, Director of Faculty Development Program, and all the participants present here. Gopalakrishnan to deliver a lecture on rights of differentially abled persons. Ma'am, please.
Thank you. Honorable Vice Chancellor, Honorable Registrar, respected Professor Madam, dear esteemed colleagues who are attending this National FTP program. Actually, this 1 hour we are going to interact on the human rights of differentially abled. Now, basically, why do you need a session on human rights of differentially abled? That is the first question that we should address. Why a session on human rights of differentially abled? Well, human rights, as all of us know, it is indivisible, interdependent, and interrelated, inalienable. So it is available to one and all. And why a special mention of differentially abled? The fact is, as human rights of equality of opportunity, human right to full equality before the law and equal protection of law, human rights of the right to health, right to psychological and physical health, everything, it is available to the differentially able people also. Then why should we adhere? Why should we talk about this particular session? Why should we devote a session to human rights of differentially able? I'll just narrate one or two case studies, which brings us the importance of this particular session. As all of us are aware, around about, I think it's 2012, a woman suffering from cerebral palsy, she was offloaded from SpiceJet flight at Kolkata airport as the pilot reported that she was unfit to fly or on her own. A woman, she boarded the flight, SpiceJet flight, and the pilot stated that, well, I'm not going to fly the flight, and you should just go out of the plane. And this woman, a teacher at Kolkata Indian Institute of Cerebral Palsy, she was told by the flight assistant to she asked for the boarding pass, and then she was asked to leave the flight, and she was put in a car and taken back to the airport. According to her, now she was taken to the airport office, and she learned at the airport office that the pilot wanted her to offload it. The assistant manager and other personnel reportedly said that they were helpless and failed to convince the pilot. The airline also refused to give her something in writing. Now, as per the Directorate General of Civil Aviation's guidelines, airlines cannot refuse to carry a differentially abled passenger. And look, this is in spite of having a guideline as to what should be done, what care should be done to a differentially abled person. We find that a person was being offloaded the flight. A second incident happened again in India, that is at Madurai, in the famous Meenakshi temple, where two physically challenged devotees, they were prevented from entering the temple as one of them refused to remove their calipers. And the incident, it was critically commended. The activists, they reported, they took this particular incident, and they began to criticize this particular activity. And according to the victim and an orthopedically challenged person, the policeman subjected this particular person to remove the caliper without, and he told that, once you remove this, I cannot move through the temple. And even in that day, again, a wheelchair-bounded man who was accompanying the victim, they were also being abused by the police person. So they also made effort to say that, the caliper should be considered as a part of a differentially abled person's body. And when, they are not being allowed to use this caliper, they will be forced to crawl inside the temple, but they were ignored. And again, a similar incident happened in the temple, that is 2 months before, when two differentially abled international sportspersons were not allowed to get inside the temple because they also refused to remove the caliper. So the third incident, which I really want to point out, was the case of a differentially abled assistant professor of Delhi University. He was affected by polio since his childhood. He was asked to vacate his house, which was allotted to him in 2008. Now, actually, the house was being allotted as a temporary accommodation until an alternate disabled-friendly dwelling was made available. Now, the temporary accommodation was being given. It was at the PG hostel in the DU campus. And a better accommodation, a permanent accommodation was being promised. But in 2012, the estate officer issued a notice stating that, he is he's an unauthorized occupant and he must leave the premises, the house. Actually, the letter came as a shock to the assistant professor because the university has not given any alternate account. No, this is also in the reported case law. So this is why actually we are discussing this particular topic, because The apathy shown towards a problem is so pervasive. People with disabilities are, they are subject to deprivation in many, many corners, in many dimensions of their life. India has one of the progressive disability policy framework, but however, what remains is that, there are huge challenges for implementing these particular policy frameworks. So that is why actually, as we are discussing this particular topic, because actually the differentially abled, that they are hidden away, they're stigmatized, and we try to ignore them, their presence, etc. So that is why we should go back to our respective universities, our respective classrooms, so that we must do our bit to make to question the discrimination, if at all any, that comes across in our forefront, and again to empower to tell our students that these are the rights that they have, and the discrimination and stigmatization is not possible. To eradicate the stigmatization. Now, friends, the term differentially abled, it was coined by the US Democratic National Committee in early 1980s, because it was a more acceptable term than the terms that we normally had been using, that is the terms like handicapped or disabled. So differentially abled, it was being coined in 1980. And again, the motivation seems to be both genuine to help people previously called as handicapped to be viewed in a positive light. I remember when this particular term was being coined, the Los Angeles Times reported that it is a valiant effort to find a kinder term than handicapped. And the committee itself shows signs of being differentially abled in the use of English. So we also followed. In India, on 7th February 2012, the Chief Commissioner for Persons with Disabilities issued a notice banning the use of the term handicapped. So we have also stopped using the term handicapped in all official correspondence, official reports, government institutions and organizations. So from 7th February 2012, what we are supposed to use is differentially abled. The terminology that we are supposed to use is differentially abled, and consequently, almost all the state governments have banned the use of the other terms, and they try to stick on to the new term, that is differentially abled. And the differentially abled, we must be aware of the human rights. We must be aware of their rights, because the problem is very, very severe, because the problem is more, the presence is more in rural areas where 8.4% of the household have at least one, have a presence of differentially abled people there. And this substantial portion of our population needs equal services and opportunities for their overall development, which is also an essential attribute for inclusive growth. So we must be aware that differentially abled people are entitled to realization of all human rights and fundamental freedoms on equal terms with others in society, without discrimination of every kind. They also enjoy certain human rights, especially linked to their status. We must be also aware of that. Apart from all the human rights that we are aware, they all have certain special needs. And for example, they have the right to a special access as far as the movement is concerned, access to the offices, universities, transport, etc. So their freedom is completely different from ours. So human right to freedom from discrimination and access to housing, education, social services, healthcare, employment, we have to understand human rights from their perspective. It is not our human rights that we are talking about, but we have to we have to understand their environment, and we have to reconceptualize the human rights from their angle. So human rights of freedom from discrimination in access to housing, education, social service, healthcare, or employment or transport. Then human right to active participation in all aspects of social, economic, political, cultural life of the society, and in framing policies and programs. Just imagine when you're talking about human rights of freedom of movement, and a person cannot step into the public transport system. So human rights of differentially abled has to be understood from their perspective. So, my dear friends, what are the provisions of human rights law? What provisions of human rights law guarantee the human rights of differentially abled persons? What about the international human rights law, which all documents speaks about the rights of differentially abled? Well, the Universal Declaration of Human Rights, it just talks about the rights of differentially abled. That is in Article 1, 2, 7, and 25. The UDHR talks about the general rights as well as very specific rights. For example, it talks with all human beings are born free and equal in dignity and rights. So that means they also have every right to live along with us and enjoy all the rights which we are enjoying. Okay, then again, the International Covenant on Economic, Social, and Cultural Rights. Articles 2, 6, 7, 11, 12, 13, and 15. Yes, it gives more importance to education. It talks about access in educational institutions, especially the primary, secondary, and higher education, everything, as far as the differentially abled is concerned. Again, ICCPR, Article 2, 7, 14, 16, 17, 23, and 26. Again, it talks about no discrimination to the people, and effective protection must be given against any discrimination. So almost all the major the human rights documents just specifically talks about the human rights of differentially abled. Then the ILO Vocational Rehabilitation and Employment Convention number 159, it talks about equality of opportunity and treatment for disabled men and women workers shall be respected. Then the vocational training, guidance, placement, employment, it must be there as far as the people are concerned. Then Article 2, 19, and 23 of the Convention on Rights of Child, again, it talks about the differentially abled people, though in a general sense, but in specific sense, again, it talks about assistance being given to the differentially abled child as an effective access to and access to the education, training, and healthcare services. And so the fact is that this international commitments, which has been reflected in the international documents, it has been the international community, actually, they debated the rights of differentially abled persons with the concern since the inception of the United Nations. So it is evident. So the debate regarding the rights of the differentially abled, it was there right since the United Nations was there. And as all of us are aware, in 1969, the United Nations General Assembly adopted the Declaration on Social Progress and Development, which started the movement relating to the rights of persons with differentially abled. So in 1969, we have adopted the Declaration on Social Progress and Development. So this declaration is one of the very important declaration because it proclaims a right to live in dignity. Right to live with dignity for all people and human beings. Again, it emphasized the need to assure the disadvantaged or marginalized section of the people with equal opportunities. So further, it also stated that, social progress and development should aim at the protection of physically or mentally disadvantaged people. So again, the declaration also suggested that the government must institute appropriate measures for rehabilitation of mentally or physically disabled persons. So in 1969 itself, we started the debate. And again, we must understand, I think early morning session, madam's session was there, Amita Danda madam's session was there. And I'm sure she had given you an awareness as to the time we took in implementing very many legislations so that, it becomes very friendly for the differentially able, especially the mentally challenged. So the mentally and physically challenged persons, so as to enable them to the fullest possible extent to be useful members of the society. So the declaration, it asks the government, you do something so that, they also be incorporated into the society. And again, the declaration also talked about measures including treatment provisions, then educational, vocational, and social guidance, then training and selective placements. Because the fact is that, there must be initiatives in the society so that, they can also be come along with us. Okay. So after this, in 1969, we find that the General Assembly, it came with two very significant declarations, very, very important declarations. It was adopted by the General Assembly, specifically on mentally disabled and physically handicapped persons. The declaration was Declaration on the Rights of Mentally Retarded Persons in 1969, and the Declaration on the Rights of Disabled Persons, 1975. So again, in 1986, we have another declaration. So we have to understand that, there is no shortage of declarations and documents. Okay, so the Declaration on Right to Development, 1986. It categorically stated that state has a right and duty to formulate national policies so that, the well-being of differentially abled, well-being of these people must be taken care of, and free and meaningful participation in the development and in the fair distribution must take place. So the declaration also talks about that. Then the Vienna Declaration. The Vienna Declaration emphatically stated, special attention need to be paid to ensure that non-discrimination and equal enjoyment of human rights and fundamental rights by disabled persons, including their active support in all aspects of society. So, we can understand that, yes, the United Nations and its subsequent declarations have given adequate importance to the rights of differentially abled, and again it is emphatically stated that, and it's also directed that the government, they must draft policies and programs so that, the rights are being safeguarded. So in 1993 to 2002, we can find that the government, the Economic and Social Commission for Asia and the Pacific, ESCAP. So in its 48th session, that is April 1992, declared that 1993 to 2002, it is a decade of disabled persons. So from 1993 to 2002, it is called the Pacific, Asia and Pacific Decade of Disabled Persons. And the proclamation on the full participation and equality of people with disabilities in the Asia and Pacific region. And again, the agenda for action for the Asian and Pacific Decade of Disabled People, it also followed. So India is a signatory to this. And what the importance of this is that, look, the issuance of the landmark documents, it is actually an encouragement to the government especially the ministries and the departments and the non-NGO organizations, to be a part of this movement, to draft policies and programs so that the differentially abled people can enjoy, can realize their basic human rights. And again, the resolution also urges the member and the associate member governments to review the situation of disabled persons in their countries, because very often when we draft a piece of legislation, we enact a piece of legislation, we implement a policy, we forget to review the same, whether the policy is working, whether the program is reaching the people. We just, we forget to understand, to make this particular review. So the resolution urges that, look, the government, please review the situation, and, you try to develop, if the measures are not being trickling down to the people, you try to develop measures so that you can enhance the full participation of differentially abled persons. And the primary focus of the decade was the formulation and implementation of national policies and programs across the world. So almost it is not that one particular country must draft and then stop. No, the formulation and implementation of national policies and programs to promote the participation of people with disabilities in economic and social development, then establishing and strengthening national coordinating committees on disability matters, then provision of assistance to the disabled persons, then promote special efforts to foster positive attitude towards the children and adults with disabilities, and to undertake measures to improve their access to rehabilitation, education, employment, cultural, sports activities, and physical environment. Now, this is very important. Again, I repeat, when we talk of human rights, it must be accessible to them. Otherwise, human rights and differentially abled, it will be in two different compartments. There must be measures so that, we have to improve their access to rehabilitation, education, employment, cultural and sports activities and physical environment. And the Economic and Social Commission for Asia and Pacific, in 2002, what they did was that, they told that in their 58th session, they told that what we need is an inclusive, barrier-free, right-based society for people with disabilities. And what they did was that, they extended the decade of disabled persons for another decade, that is 2003 to 2012. India is again a signatory to this. So the resolution, again, another plus point of the second resolution was that it incorporates the MDGs, the Millennium Development Goals, also into this, and their relevant targets to ensure that concerns relating to persons with disabilities became an integral part of the MDGs also. So from 2012, we have 7 priority areas. Okay, we have 7 priority areas. That is, the first priority area is self-help organizations of persons with disabilities and related family and parent association. Then we have women with disabilities. Then early detection, early intervention and education. 4th one, training and employment, including self-employment. 5th one, access to built environment, public transport, information and communication, including assertive technologies. Poverty elevation through social security and livelihood programs. So these are the 7 priority areas for action, targets and strategies. Time framework was also being given. So if we just critically review all these 7 priorities, what is the attitude that we have towards women with disabilities? What is the attitude that we have with children with disabilities? Do we have enough programs and policies for early detection, early intervention and education? Do we launch programs and policies for training and employment and including self-employment? Do we have the perfect environment wherein each one can barge into any office across without the help of any people? Can they apply on any transport without the help of any people? Can they have an access to information and communication, including assertive technologies? And what are the poverty elevation programs through social security and livelihood programs? So we have to read the sense that the human rights sense, the ethos that we have in our mind into these 7 priorities. Actually, we have to step into their lives, into their shoes, and then we have to understand the human rights of differentially abled. Now, the UN Convention on the Protection and Promotion of Rights and Dignity of Persons with Disabilities, we signed this convention, UN Convention, on 30th March 2007, and it was ratified in October 2008. And this convention also, it recognized that disability, it is an evolving concept, and disability results from the interaction between persons with impairments. Now, what the convention stated was that we must break the attitudinal barriers first. The attitudinal barriers of the society is the hindrance for the people to enjoy human rights, to realize their human rights. So the attitudinal barriers must be challenged, it must be broken, and the environmental barriers which hinders their full and effective participation in the society, it must be challenged. So what is important, what the convention stated was, you should never forget that you must never forget the importance of mainstreaming disability issues as an integral part of relevant strategies of sustainable development. So that is what the UN Convention stated. And again, it also stated that the state parties, you must undertake and ensure and promote the full realization of all the human rights and fundamental freedom for the persons with disabilities without discrimination. So the convention had very specific directives. Since time is very short, I'm not detailing all the entire directives, but I'll just mention 4. It stated that we have to immediately adopt appropriate legislative and administrative measures for the implementation of rights recognized in the present convention. Secondly, the convention stated that please take appropriate measures, including legislation, to abolish existing laws, regulations, customs, and practices that continue to discriminate persons with disabilities. You immediately pass laws so that, all these, the discrimination against persons with disabilities are being stopped. Then, to take into account the protection and promotion of human rights of people with disabilities in all policies and programs, and take all appropriate measures to eliminate discrimination on the basis of disability by any person, organization, or private enterprise. To undertake or promote research and development of, and to promote the availability and use of new technologies. So when you're talking about current years, we must make use of new technologies, including information and communication technologies, mobility aids, and device and assistive technologies suitable for people of disabilities, and so that, you can reduce the cost of the technologies that we are talking about. So following this, following these 2012, that is from 1993 to 2002, which was being proclaimed by the General Assembly as the UN Decade for Disabled Persons, a global movement emerged which recognizes the importance of integration of people with disability into the society. So that was the most important attribute of this particular movement. So there was a global movement which emerged, which recognized the importance of integration of people with disabilities into the society. So again, there was an emerging trend across the world which stated that, look, it is the bounden duty of the government, it is the bounden duty at the national level to make policies and programs, to make the professionals, to make the policy makers, so that we enact newer and newer policies, so that it becomes quite friendly to the differentially abled. So as a result of the shift in policy, we find that issues relating to disabled are no longer mere welfare measures. It is not mere welfare measures, or it is not mere something that we should give to them or the government should give to them. It is grown to a fundamental human rights issues where the differentially abled people demand for full participation, equal opportunity and protection of rights. It is their rights. And every government, they have to assure it. So the shift has led to the realization for the need of legislation to ensure empowerment. So from a welfare measure, now it is a fundamental human rights issue, and which is being backed up by legislations to ensure empowerment. And what is the attitude of India? Is this attitude reflected in India? What is the approach that we adopt in India? Yes, the international reflection, it has been actually assimilated in India also. So in India also, it has been assimilated, and the Constitution of India ensures equality, freedom, justice, and dignity. Quite often we forget this. The Constitution of India ensures equality, freedom, justice, and dignity of all people. And implicitly, it mandates that it is an inclusive society of all persons, which includes people with
Madam, please unmute your mic, madam.
Okay.
Yes, ma'am. Yeah.
I'm sorry for the technical snag. I just had two calls in between.
Fine.
So that's why. Sorry.
Yes.
So in the Constitution of India, it also, as we were discussing, the Constitution of India ensures equality of freedom, justice, and dignity. And so it also includes persons with disabilities. And apart from that, the Constitution envisages, it talks about directive principles of state policy. In Article 41, it says that within the limits of economic capacity and development, make provisions for securing the right to work, to education, and public assistance in case of unemployment, old age, sickness, and disablement. So it is there in the Constitution. And again, the 7th schedule of the Constitution, it confers the responsibility of the relief of the disabled persons and unemployable on the state under entry 9 of the state list. Then further under Article 243G and 243W, there is a devolution of powers, authority and responsibility on the urban and the rural local bodies to devise and implement schemes concerning in their jurisdiction for the people of disabled, differentially abled. Then the 11th schedule under entry 26, it entrusted social welfare of the handicapped and the mentally challenged people to the rural bodies. And the 12th schedule under entry 9, it requires the urban bodies to safeguard the interest of the differentially abled and the mentally challenged people. So the Constitution, it is that the Constitution definitely it has taken into account the human rights, the rights of differentially abled. Now, what about, did we go further? Did we take the provisions of the Constitution further? What did we do? So the legal commitment that took place to ensure the empowerment of the persons with disabilities took shape with the enactment of the Persons with Disabilities, Equal Opportunities, Protection of Rights and Full Participation Act in 1995. And actually, this is a very comprehensive piece of legislation, which it covers basically almost all the aspects of the persons relating to disabled persons. So the fact is that we enacted a legislation, and then what happened was that we didn't stop there. The government of India didn't stop there. We have launched legislations. We have drafted policies and programs. I'll just quickly mention the legislation and the policies and programs very quickly, so that we can take up the questions. So the Persons with Disabilities Act 1995, it has been enacted under Article 253 of the Indian Constitution. It gives effect to the full participation and equality of the persons with disabilities, and definitely it is a comprehensive piece of legislation, and it treats the importance. What I feel is that the importance is that it treats rehabilitation as a right. Okay, it is a right, and the elimination of discrimination and creation of a society with equal opportunities. That is the plus point of the Act of 1995, and And as far as in continuation this with the Persons with Disabilities Act, we also have the Rights of Persons with Disabilities Act of 2016, the RPWD Act of 2016. And when the Persons with Disabilities Act of 1995, it defined disability, and then it also enjoined the government to identify posts which can be reserved for the persons with disabilities, and appoint in every establishment percentage of vacancies must be demarcated for the people differentially able. It must be given to them, and then it was stated that not less than 3% must be reserved for them, and then again, the having hearing impaired, for example, for blindness, for low vision, for hearing impairment, locomotive disability, or cerebral palsy, you have to reserve that for the people of and so all sort of provisions are there mentioned in that particular act. It also provides for the appointment of a chief commissioner for persons with disabilities at the centers, at the states, for ensuring that the implementation of the act is being carried out. And if we just critically review, at times, in reality, look, truth is always different from reality. I'm sorry, the legislations, it is always different from reality. And sometimes, what happens is that as far as I feel comments there, look, reservations. Yes, reservations are there. Reservations are there in the job sectors. For example, I'll tell you, last year we had called for the vacancy of an assistant professor at MG University. So we had a post reserved for a person for differentially able. Yes, it is there. And so the fact is that these provisions, the fact, to what extent are we understanding the provisions and are we implementing these provisions? That is a question. And again, the Act, I was also talking about the Rights of Persons with Disabilities Act of 2016. So the Act, it was being implemented in 2016. It came into force in 2017. And again, the salient features of the Act was that, the responsibility it is being cast upon the appropriate governments to take effective measures to ensure that the persons with disabilities, they enjoy their rights equally with others. So that is the importance. It is not that, they must have rights, but they must enjoy their rights equally with others. Then disability has been defined on an evolving and a dynamic concept. So that is the difference between the two acts. And the Act covers very specific disabilities also. For example, physical disabilities. It has been divided into locomotive disability, then visual impairment, hearing impairment. Then, for example, hearing impairment has been divided into being deaf and hard of hearing. It is there. Then speech and language disabilities being defined, then intellectual disabilities being mentioned in the Act. For example, specific learning disabilities, autism spectrum disorder. When we talk of specific learning disabilities, as parents, sometimes, we fail to understand the learning disabilities of our children or the children who are before us as our students. We terribly fail in recognizing their learning disabilities. If a person cannot write spellings properly, if they cannot write properly, if they cannot catch up with others, we fail to understand their plight. So intellectual disabilities, specific learning disabilities, autism spectrum disorder is there. And then the mental behavior, the mental illness has been defined. Then disability caused due to chronic neurological conditions, for example, multiple sclerosis, then Parkinson diseases, it has been mentioned. Then the blood disorders, hemophilia, then thalassemia, and sickle cell diseases, it has been mentioned. Then multiple disabilities, that has also been mentioned in the Act. Then again, additional benefits has been provided with persons with benchmark disabilities, as these, they need high support needs. So again, the Act also states that, every child with benchmark disabilities between the age group of 6 to 18 years shall have a right to free education. My dear friends, when we go back to our respective classes, when we go back to our respective areas, when we get back to our work, all these provisions must remain in our mind. So, and we must be warriors in this particular area, so that, we must understand that every child with benchmark disabilities, they shall have a right to free education. And 5% reservation in seats in government and government-aided higher education institutions for persons with benchmark disabilities. And again, stress is being given to ensure accessibility in public buildings within a framework. Because definitely many of the universities under the UGC compliance, because of the NAC issues, we have made very ramps, etc., for the differentially abled. Then again, the Act talks about broad-based central and state advisory boards on disability to be set up as policymakers. So apart from these major two legislations, we have in 1999, the legislation was being made for that, for example, then for setting up of National Trust for welfare of persons with autism, cerebral palsy, mental retardation, and multiple disability. It was being introduced and passed in the Parliament in 1999. What the Act ensures is that, it provides for constitution of the board of the National Trust, local government, local committees, accountability and monitoring of the trust. And again, here also the Act talks about definitions of autism, cerebral palsy, mental retardation, persons with disability, severe disability, etc. Then again, I should mention the Rehabilitation Council of India Act 1992. This is a regulatory body just like the UGC that we are familiar with, the Rehabilitation Council of India Act of 1992. It provides for standardization of training courses at different levels, recognizing institutions. For example, if you have to start a new course, definitely you have to get the permission of Rehabilitation Council of India Act. And then, you have to start the courses. So the Rehabilitation Council of India Act 1992, where again, handicapped, hearing handicapped, locomotor disability, then mental retardation and visually handicapped, they are being defined. Then the national policy for peoples with disabilities, it was being enacted in the year 2006, the national policy for peoples with disabilities. So again, it recognizes that persons with disabilities are valuable human resources. You must understand this. You must understand the change that is being reflected in the government's attitude. Look, persons with differentially abled persons are valuable human resources for the country, and we should provide them an environment that it ensures equal opportunities, protection of their rights, and full participation in the society. So the focus of the policy, it was prevention of disabilities and rehabilitation measures. So one particular policy of this national policy, it is economic rehabilitation for a dignified life and educational rehabilitation, including vocational training. So this is a policy, again, it's a very friendly policy. And again, the policy also have special focus on women and children with disabilities. Then again, I have also already talked about the new legislation. And again, apart from that, what are the infrastructure for empowerment? What are the infrastructure that we are talking about? Yes, we have the Ministry of Social Justice and Empowerment. We have the Office of the Commissioner, Chief Commissioner for Persons with Disabilities, and National Trust for the Welfare of Persons with Autism, cerebral palsy, mental retardation, and multiple disabilities. Yes, we have that. We have the Rehabilitation Council of India. We have that. Then we have the Indian Sign Language Research and Training Center. That is so that, and also we have the Artificial Limbs Manufacturing Corporation of India. It is in Uttar Pradesh, which manufactures artificial limbs, accessories, and constituents thereof, and promotes their availability, supply, and distribution at reasonable cost to the disabled persons and hospitals and other institutions. So the Artificial Limbs Manufacturing Corporation, it is a premier organization and is the largest manufacturer of artificial limbs components and our rehabilitation aids for disabled in India. Then we have the National Handicapped Finance and Development Corporations, Faridabad. Then we have the Composite Regional Centers for Persons with Disabilities, CRCs. It is there. And again, we have the Indian Spinal Injury Center. We must be aware of this particular center because this center provides comprehensive rehabilitation management to patients with spinal cord injuries and related ailments. So these include interventions in the form of reconstructive surgery, stabilization operations, physical rehabilitations, psychosocial rehabilitation, and vocational rehabilitation services. Then there has been a number of free OPD services. Again, there is also paid OPD services. The free OPD services are there. And again, look, the bed facilities, etc., also there in the Indian spine industry. Now, apart from that, we also have the judiciary supporting all these initiatives. For example, you have case laws. The fact is that, you know, it is now the traditional judicial framework that goes on, but the role of the judiciary is very significant, because the judiciary does not follow the old typical language of the statute, but it adopts a very friendly attitude towards the persons with differentially abled. For example, cases like Javed, the BD versus Union of India. Then you have the National Federation of Blind versus UPSC. Then you have the Chandan Kumar Bainaik versus State of West Bengal. All those cases, you know, it gives you the feel of the judicial activism that is going on as far as the rights is concerned. Then towards the end, yes, the welfare plans. Yes, the welfare plans, because, you know, when we talk of legislations and judiciary, it must trickle down to the people. So what are the welfare plans that we are talking about? We have the barrier-free built environment, because the Central Public Works Department, it has issued a comprehensive guideline for barrier-free environment to make buildings and facilities friendly for the people with disabilities. This is something which we must give due importance. Our buildings, our transports, our office, you know, it must be very friendly for the people with, for the differentially abled people. And, you know, the Central Public Works Department has given a guideline, has given a comprehensive guideline for that. And accessibility norms is to be followed by the government. And again, especially almost all the universities, you know, we have been adhering to this barrier-free built environment. Especially our students, you know, they should never feel a barrier in accessing, coming into the department. So it has been made mandatory. And the ministry also made the model building bylaws, which contains how to improve the access to various public buildings by disabled and elderly persons. Then differentially abled athletes to get the same treatment as regular ones in promotion. So the cabinet has decided to treat persons with differentially abled persons on par with the others in the service matters, especially whether they are in the public employment also. This was the first move, because, you know, even though it was being introduced in the athletic field, again, it was being extended to the other fields also. Then again, reserving jobs for the differentially abled, especially in the IT sector and the BPO jobs for the differentially abled. And again, financial assistance for persons with disabilities. So we have the Deen Dayal Disabled Rehabilitation Scheme, DDRS. Then assistance to the disabled persons for purchase of fitting of aids and appliances, ADIP. Then the national institutions are also given supports. Then the National Handicapped Finance and Development Corporation, they have also given the guidelines. They have provided concessional credits to persons with disabilities for setting income generating activities for self-employment. And so these are, actually, I've started with the international arena. I stated that, yes, human rights are equal. It is available to one and all, but we must understand these human rights from the perspective of differentially able, so that, you know, we can assure them a meaningful human rights. And we have also understood there are a couple of international documents which speaks about the rights of differentially able, which assures rights to differentially abled persons. Then coming down to India, all the international assurances, it has been read into the Indian legislations, whether it is the 1995 or the 2016 Act, it has been there. The policies and programs are there. And again, Again, the judiciary has also been giving an excellent support to this. So what more has to be done? The first thing is that understand their world, understand their rights, never discriminate the differentially able people. Treat them on par with us. What we need more is the attitudinal changes rather than wait for legislation to make changes. We have to change ourselves. Then only we can assure that our friends who are differentially able are also on par with us. Thank you. I'll share the PPT. I've also already made a PPT. I'll share it with Madam. I'll share it to Madam so that you can have a copy of that.
Thank you for such an informative and insightful session, ma'am. I now request Dr. Rangaswamy, Assistant Professor of Karnataka State Law University, to ask the questions to the resource person on behalf of participants.
Thank you, madam. Thank you very much for your comprehensive and consolidated ideas. Indeed, we are so fortunate to have you as resource person for this technical session, madam. So the clarity in your idea, certainty in your thoughts would certainly streamline our participants' approach in integrating and analyzing divergent issues relating to persons with differentially abled persons. Madam, now this is the time for question and answer. In fact, there are many questions, madam, posed by the participants. Due to positive time, as it is our time to take up those questions, I will be asking only one question, madam, so that could answer. So the question is like criminal liability. Applicability of the criminal liability for a differentially abled person, whether equal to the normal person, or are there any relaxation for differentially abled person? So that is the question, ma'am.
Just a minute, I just had a call in between. Just a minute.
Shall I repeat, madam, that question?
No, I have to take an urgent call from the university. Just a minute, I have to take a call.
Okay.
Hello, sir. ഞാനൊരു FDP സാറ് പറഞ്ഞോ sir. Sir പറഞ്ഞോ sir.